Etifu kwa baba de Likee TV na message na oba channel iso hita to man subscribe na like send drop in latest news content obejebre na also onsa so etimi akabi na ye bowra ensem ni ma etiefo mobeka ya Supreme Court ho nsensemi Justice Atuguba ebe clear ebe defend abambaben chire mu be chire kwanya Supreme Court nka kwa mo fa so nka ewuli case no but ense omu rule in favor of NPP mo be clear ehun semni nyina nanu na NPP lawyers ni bi attack Atuguba and NDC for so debi because yen tena ho ma mo fa Justice Atuguba ni mo nya form ne nsem a wakanti munti make kane ma mo pe enkyere no na etifo wo ma retaliate amane wo mo pa na mepese you problem ni tie nsem ni bia ba de kan ho no menso mabo nsem ni na no me de beba bedum.
Quick one.
The Supreme Court made it clear at page 14 of the judgment that they are doing only interpretation, okay, and so that anybody after this interpretation who wants to have those seats declared should go to the High Court. Let's repeat. So the Supreme Court is saying that this judgment, the majority, okay, it's only an interpretation. They are not in the business of declaring vacant seats. Vacant seats is for the High Court.
So
under Article 99.
That pending the Fiamekpo case at the High Court,
yes.
this ruling doesn't affect it.
That's the right forum. The Fiamekpo is in the right forum to have those seats vacated. If you want to vacate a seat and you go to the Supreme Court, you'll be thrown out. So they are very clear. That's how come they said they are not declaring any seats vacant. They've just declared that what the speaker did is wrong. Now, if you actually want them to say that this seat, okay, should be declared vacant, go to the High Court. That's the law, right? Now, let's also come to this point briefly. Prof, I appreciate the historical antecedents and everything. By an interpretation, when we talk about the intention, when you hear lawyers say intention of the lawmaker, the intention simply means what the lawmaker has captured in the black letter of the law. So I get it that the core of cross-carpeting or crossing carpet, I didn't know there was cross-carpeting. We were used to crossing carpet. That now they say there's also the version cross-carpeting. Right, I'm a political scientist by training, right? So I appreciate that that's the core one, but it also covers beyond. So if we want to limit it to only the one you're talking about, that in Parliament fiscally crossing, then let's limit it. Otherwise, you see, the Speaker is the most experienced parliamentarian from 1992. He's saying it, and he's saying that it doesn't make sense. Before you can become a parliamentary candidate of a party, you go and join that party. And so they say break in allegiance. Now, you're saying that, look at Mamle, Morrison, etc. They've only kept them because MPP doesn't have the numbers. Otherwise, you think MPP is happy that, let's say, they go to have their strategy meetings and then Mamle Morrison is sitting there. When they see her as a mole...
As a that's a minimal issue which
no, it's not minimal. That's why under Act 300, the Parliament Act, it's the political parties that have control over their members. Once you break allegiance, they send you out.
Okay.
Once you break allegiance, they send you out. So what the Supreme Court was needlessly engaged in is rewriting the Constitution. No, don't rewrite when the words are very clear. The purposive interpretation approach says that when the words are clear, just give them their meaning. Please. When a law is undesirable, you amend. We all agree now that it's time to review the Constitution. So we'll simply add it. If the wishes of the people is that we should limit it to only actually cross-carpeting from one side of the aisle to the other, sure. But Speaker Bagbin's ruling is that allegiance is very, 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 very important. And also let's note that in contract, there's what we call laws in restraint of trade.
Yes.
Simply, the aspect I'm interested in here is that, assuming Mr. Okansi is a host of this program, your contract of employment can provide that if you resign today, tomorrow you cannot go and join Samson Ladi and on Joy FM so that you'll be two hosts of the program. No. Under the common law, it's allowed that your contract will restrict you that you cannot immediately go. but rather they can put in there that you sit at home for 6 months. Of course, they'll compensate you for that. But you have to make sure that you don't immediately go away with trade secrets and everything from here. It's law. So when the Constitution says that don't join this different party and seek to remain, there is also a reason for it. There are these issues of secrets, etc. So let's not just say that, oh, the only purpose of Article 97 Clause 1J and H is that when you fiscally cross. No, you become dangerous.
So it's not a trivial issue at all.
Yeah.
Okay, and Mr. Safa, on this matter, because when I asked that question earlier, said this is one that you would treat as a trivial issue because you would rather leave that to be determined by the leadership of the party, to the extent that if you have these persons who not just express an intention, because we have the notice of poll that has captured not just an intention, but a reality that they are going to contest as independent candidates in their respective constituencies. No, let's put the notice of polls on the screen. Yes. No, I'm going to a point. Against the elected and sponsored candidate of your party.
To join the next parliament.
No, yes. I mean, that's stated.
So add it.
You say that to the extent that they have their intentions impacting the next parliament, it's okay for them to remain in your fold and attend all your strategy meetings and so on. It's okay for you as a political party. Now, take a look at this. This is not just an intention. It is a confirmation of their intentions by the Electoral Commission. And this is it. Let's look at the Sohum constituency. The Sohum constituency has Frank Esiedu Bekoin, Protozwa, as the sponsored NPP candidate. Ernest Ofori Dangbe, Ernestina, I beg your pardon. Let's go to the Sohum constituency. The Sohum constituency. Let's flip to the Sohum constituency. And the Sohum constituency has Protozwa as the NPP candidate for the Sohum constituency. Then you also have now, as advertised, the Prince Ado of the NDC, Emmanuel Dede Wiafe as an independent candidate, and then Kojo Asante as well, who is the incumbent MP on the ticket of the NPP, contesting as an independent candidate. That is a notice of poll by the Electoral Commission. Then Agona West constituency, Christopher Atta of the NPP, that's a sponsored candidate, and Ernestina Ofori-Dangbe of the NDC, and Cynthia Mamle Morrison, who is an independent candidate in this election against the sponsored candidate of the party. But she's serving as the incumbent in this 8th parliament. Then you have Amenfi Central. Let's flip to Amenfi Central. That's the Amenfi Central has Albert Redu Akun, Peter Yalkwachiaka, and now there's Joanna Jankujo. Let's flip to the next one. That's it. And then Carl Mark Ahin, also an independent candidate. So it is not just an intention now, Josepha. That's what you see there.
Let me help you.
No. Let's
Let me defer to just a second. What do you want to say?
He said he wants to defer to you. As a first today, I'm on our side. You see, I'm saying that Akroma, using the notorious Preventive Detention Act, sought to reduce the numerical strength of the opposing parties, you know, in that parliament, okay, by forcing them to cross carpet, okay. And I'm saying that in the case of J. Brahma, his Catholic bishop had to go to Akroma to go and beg that please, we want to come and join you so that you stop worrying us. Okay, and my question is, so the idea of cross-carpeting must always be judged when it weakens the numerical strength of political parties in the current parliament. What has happened, I'm asking myself, how does, what has happened? How does it weaken the numerical strength of the NPP? It doesn't. If they are counting their numbers right now, even though Cynthia Morrison is going for independent, today, if there is a decision to be taken on the floor of parliament, Cynthia Morrison adds to the numerical strength of the NPP. Doesn't. So I think this is what
they left her because they don't have the numbers. When they had the numbers, Esiama didn't they quickly ask that remove Esiama.
Okay.
So you are going to lead to this selective application of the constitution. Not consistency. That is why you left out.
Yes. I have my say on this. I hope you come quickly. I have a lot to say about what Justice Atuguba said. But before I come there, let me quickly take this issue off. With the issue of the notice of poll, what is the reasoning behind a notice of poll? The reasoning behind a notice of poll is to show that these candidates would want to contest and be part of the next parliament. I don't see why or how a notice of poll should be enough justification to show that my current status as a member of parliament has been affected.
Allegiance.
And not that of the future parliament.
Allegiance.
So the point I'm making is that notice of poll is not enough.
Don't you join a party before you get notice of poll?
I have left.
Don't you join a party before you get the notice of poll?
The party that I was joining when I had a social contract. Secondly, Alfred, you allowed Justice Atuguba to use derogatory words
what is derogatory?
The Supreme Court.
What do you mean? Don't worry. What do you mean?
To even attack them. They are using the court as a political platform.
Was it? Hold on.
Of course, so
it's not analysis.
No.
Can I have?
If you are using words as derogatory and attack, he analyzed a situation about the state of affairs with the Supreme Court.
Did he use words saying that Did you use words like the Supreme Court has been used as a platform for politics?
No.
Can I finish? Let me finish. Please give me 2 minutes. Let me finish. Justice Atuguba's comment lacked so much principle.
In what sense?
In the sense that, let me bring you to some of his decisions. In the case of Federation of Youth Association of Ghana versus Public Universities of Ghana and others, 2010. That is 2010, when he was a member of the Supreme Court judges. He had the occasion to comment, or if you like, he supported the majority decision, the decision that was read by Adinyira JSC. In that case, Adinyira JSC, which Atuguba was presiding, which he supported and was part of that majority decision, espoused what concurrent jurisdiction is. When we talk about concurrent jurisdiction, we are talking about a jurisdiction that can be had by one other court and another. In this instance, the Supreme Court and the High Court, concurrent jurisdiction. And this is what Justice Atuguba had to say. My lords, although the jurisdiction of this honorable court to interpret provisions of the 1992 Constitution is exclusive and resides jealously only with the court, the debate has raged whether, relative to enforcement of provisions under the Chapter 5 of the Constitution, this honorable court has concurrent jurisdiction with the High Court. This is Adinyira JSC. Now, when
he made reference to that particular case, didn't he?
So hold on. Yes, so I'm coming to quote what he himself said. This is Adinyira JSC. What he himself said. He said that, and he relied on the case of Ejiampofu and AMA. Versus Ejiampofu versus AMA and Attorney General. And that case was in 2007. Which defeats his own argument that there has been a certain line of cases that this particular Supreme Court has deviated from. And those line of cases includes Sam versus Attorney General, Eduse versus Attorney General, Ejiampofu versus Attorney General. And in the case of the Federation case, this is what he himself said. And the jurisdiction of the Supreme Court is not ousted simply because of the provision sought to be enforced. The court's jurisdiction in such a case is determined by whether or not the plaintiff is pursuing a personal interest, as in the case in the Eduse and Bempombuta cases, as well as the case of Upon versus Attorney General.
So what's your issue there? When
there are issues bordering on fundamental human rights, you need not show a personal interest when you want to go to the Supreme Court. The Supreme Court has a concurrent jurisdiction with the High Court with issues of fundamental human rights. And this is even confirmed with Article 130. Article 130 says that subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedom as provided in Article 33 of the Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters inclusive of the provisions in Chapter 5. That is fundamental human rights. So the Supreme Court has concurrent jurisdiction to sit on all matters inclusive of the provision of Chapter 5. So Justice Atuguba cannot say, especially in his own judgment that he has
the judgment you reference. At what point is that variance with what he said today?
Exactly.
No, at what point exactly? What is it that variance?
You see, he was trying to say that in the cases of McKinney and all, these are recent cases, which the Supreme Court has deviated from, especially also in the case of Afenyo Marken versus the AG, from older cases. And now I'm pointing to you those older cases which he himself was part in 2007 and 2010. There hasn't been any deviation. The Supreme Court has been very consistent from its decision when it comes to jurisdiction. And I am saying that in terms of jurisdiction,
you read his position in part. You would have done our viewers and listeners some good if you read his position in full as espoused. What you've just read is the preliminaries of what he said in that particular case.
Albert,
it not?
Sorry, Alfred. I'm saying that.
No, I need to put that on record.
He's saying that.
This is not the full complement of his ruling.
In the long decided cases over the period, the Supreme Court in this particular case, that is Afenyo Marken versus the AG, the Speaker of Parliament, the decision that emanated from the court is a total deviation from what has been happening. And I am pointing to you those older cases, some of which he himself was part, which he supported the very decision of this particular case, which is Afenyo Marken versus the Speaker of Parliament, where he agreed with the majority decision that concurrent jurisdiction can happen or can arise where the Supreme Court and the High Court will have the same jurisdiction to pronounce on the matter. In this particular case, when it was bordering on the fundamental human rights of persons. And I'm suggesting to you that because of Article 2, when there are issues that is bordering on fundamental human rights, you don't necessarily need a personal interest.
But no.
Hold on. Because this one, you see, Afenyo Marken did not have a personal interest in this matter. So he decided to, based on Article 2 and 130, its combined effect, to go to the Supreme Court to invoke the original exclusive jurisdiction of the Supreme Court. So Justice Atuguba cannot say that this Supreme Court has deviated from the older cases. And I'm suggesting to you that those older cases, some of which he himself has been part, have supported the current position of the Supreme Court.
So
it cannot be the case that there has been a deviation.
Didn't have personal interest in this matter. It depends on how you look at it.
Exactly.
You say he doesn't have a personal interest in this matter.
Fundamental human rights has not been affected. Fundamental human rights of certain 4 persons has been affected. And for that matter, he himself do not have a personal, personal interest in the matter.
How do you argue this?
Versus AG. Did he have a personal interest?
No. It's about latrine. Do you know what the facts are? Latrine. People carry latrine. Was it Ejechum who also they said Ampofo? Was he the one to carry the latrine?
So
he's a lawyer. He doesn't carry latrine on his head. By this one, Akroma was there to make sure that the 4 seats, the 3 at least out of them are retained, so that they will continue to have a majority.
The issue of whatever happens in Parliament is a closed book. So what JSC said in 84 versus Attorney General, that indeed whatever happens in Parliament is a closed book. That was the 1980 case. So what JSC, based on the 1979 Constitution and its provisions to make such a pronouncement, in our current Constitution, Article 125 is very clear when it says that final judicial power resides with the judiciary. So irrespective of whatever happens in Parliament, especially when there is a ruling, which ruling I am saying that first and foremost, the Speaker of Parliament did not have that jurisdiction to even give that ruling. Because if you listen to what my Honourable Member Sam George said, then the Speaker of Parliament should have deferred or should have allowed any member of parliament to have gone to the High Court to declare those seats vacant because he himself did not have that jurisdiction to do so. Okay. If that is the argument to go by. Because Article 1253 is very clear. The final judicial power rests with the judiciary.
It doesn't mean people cannot interpret the constitution.
And so,
you interpret it the way
if the Speaker of Parliament makes a ruling in Parliament,
Yedamase samoje bre so daily update TV ne bese se tembia no aha na mon subscribe na mon like see drop any latest news content a mon so mo beje bre na mon so mo nya bi atie